Hello, I'm Dr. John Kavanagh, and welcome to AJS101, Introduction to Criminal Justice, Lesson 7, Part 1. This chapter is about how the courts work at the federal, state, and local levels. Now, the United States has 51 court systems, one in each state, and the federal court system. There is no single court system for the entire country at all levels of government, because the founders of our government feared an all-powerful and oppressive government, so they decentralized the power of the courts. So let's first talk about the state courts. Most state courts have 3 court levels: trial, appellate, and state Supreme Court. The lowest level is the trial court level, and on the bottom of the trial court level are the courts of limited jurisdiction. These courts hear less serious cases like traffic infractions and violations. And judges usually decide guilt or innocence, and there are no transcripts kept. A transcript is a written record of what goes on in the court. It looks very much like the script of a play, where the name of the person appears, followed by what the person actually said. And if things were moved around or shown, that is listed as defendant X, stood up or, approached so-and-so. So it's kind of like a play script. And the reason why transcripts are important is that they provide a written record of what happened, so that if there's an appeal to a higher court, the judges that are reviewing the appeal can see exactly what happens, so they can rule better on the appeal. And finally, in these limited jurisdiction courts, the procedures tend to be informal. You generally don't have to have a lawyer. You drive around, you see these courts. They're sometimes called municipal courts. They're sometimes called justice of the peace courts. Maybe you've gotten a speeding ticket and you've gone there for your case. The next up the scale are the general jurisdiction and special jurisdiction courts. Now, these courts can hear any case, but they generally hear more serious cases. And they also may handle appeals from the courts of limited jurisdiction. Now, at the general jurisdiction and special jurisdiction levels, remember, these are above the limited jurisdiction levels, the procedures are formal, and they involve prosecutors, which are lawyers hired by the state to prosecute people, and defense attorneys, who, in order to appear before a court, have to be lawyers who have been admitted to the bar. And at this level, you have an adversarial proceeding. In other words, the two attorneys, the prosecution and defense, battle each other with facts in an attempt to convince the jury, or sometimes the judge if the judge is deciding, but at this level, juries usually decide the final verdict. There are also special jurisdiction courts, and they hear special cases, like divorce courts, which would handle family matters, juvenile courts, which would handle young people charged with criminal crimes, probate courts, which handle estates, what to do with people's property after they die. Those are special jurisdiction courts. And again, they're also formal, and lawyers are involved. Now, above the level of these trial courts, you have the state appellate courts. And many states have 1 or 2 tiers of appellate courts. Now, what is an appeal? An appeal is when one party in a lower court action asks a higher court to review perhaps a judgment or a ruling or an order of a lower court. To conduct the review, the appellate judge or judges, sometimes there's a 3 or 5 judge panel, read the written records of the lower court, the transcripts, and they sometimes might hear oral arguments from the lawyers representing both sides. When an appellate court finds in favor of the appealant or the appellant and against the appealee, the court remands, which means sends back the case to the lower court for a new trial, or perhaps if the error was not really serious, a directive to correct the error and resume the lower court adjudication. When a conviction is overturned by an appellate court or a statute is ruled unconstitutional, the losing party can appeal all the way up to the state Supreme Court. Now, defendants who claim that their federal rights were violated can also appeal directly to the Supreme Court or to the local federal district court. But that's only if you're claiming a violation of the U.S. Constitution, which is considered a more serious procedural violation. So again, let's recap. You have your trial courts, limited jurisdiction for minor stuff, general and special jurisdiction for more serious things. If at the limited jurisdiction level, somebody thinks the judge made a mistake, you can do an appeal up to the general jurisdiction court. Although that appeal becomes somewhat difficult because there's no transcript. Because at the limited jurisdiction level, you may recall, they don't do transcripts. When errors are made in the general jurisdiction or special jurisdiction courts, those appeals go to the state appellate courts. And there you have panels of judges which review the transcripts and may take testimony from the lawyers to see if, in fact, an error was made by the judge in the lower court, or perhaps information was stated that shouldn't have been made known to the jury by one of the attorneys. And it's serious enough to require that the ruling or the judgment or a verdict has to be reversed or sent back for a do-over, so to speak. Okay, let's move on. The highest court in each state, and there's only one in each state, is the state Supreme Court. And the Supreme Court is the highest court in the state, and they only hear appeals. These state Supreme Courts usually have 7 to 9 justices, depending on the size of the state and the number of cases that are heard. And these justices choose the cases they wish to review. If you're a limited jurisdiction, general, special jurisdiction, you're a state appellate court, you have to entertain all of the cases that come to you. The Supreme Court, because there's only one court and has limited resources, they pick and choose the cases which they believe need to be heard. Now, let's move on to state court administration. The day-to-day operations and the long-term planning of state courts are so complex that courts generally hire non-lawyer administrators to run them. And these administrators pay the bills, hire and fire personnel other than judges, prepare the budget, perform liaison services with other branches of government, and perform a host of other administrative duties. In the old days, the chief judge was the court administrator. And this was problematic because judges are lawyers trained in law schools. They are not administrators who have MBAs or other business degrees, which is what you need if you're going to run some sort of government or even private operation or business. So the courts rely on non-lawyer administrators to actually do their day-to-day operations, pay the rent, make sure that the heat is on, hire, fire, and all the other tasks that have to be performed. You also have, in state courts, dispute resolution centers. In order to relieve the courts from ever-growing caseloads, some states have set up informal dispute resolution centers, and they attempt to resolve minor criminal matters using defendant-victim mediation. Mediation is when a neutral third party sits in a room with the disputing parties and attempts to broker a compromise or a deal so that they can settle without going to a trial and other things like that. So those are the dispute resolution centers that try to relieve the courts of some of their burden. All right, let's go into the federal courts. The federal courts were created in the United States Constitution, and the federal courts deal with cases arriving from the federal law, treaties, and the U.S. Constitution. So the federal courts deal with cases arising from treaties, federal law, the U.S. Constitution. And the federal courts operate on a 3-tiered system. There is the district courts, there are the courts of appeal, and the Supreme Court. And as you may now notice, that's very similar to the state courts, where you have the trial courts, which are, in this case, the district courts, the appellate level, and then the Supreme Court. Let's first start with the federal district courts. These consist of, the U.S. is divided into 94 districts, and they're throughout the United States and its possessions, like Puerto Rico. Now, these district courts are trial courts that have original jurisdiction over all violations of federal law. And the judges, these district court judges, are appointed by the President of the United States, but they must be confirmed. They must be approved by the Senate. And they serve for life. This makes them independent of political pressure. Now, there are also magistrates who assist district court judges at the district level by holding arraignments and also issuing warrants to federal law enforcement personnel. And these magistrates are lawyers. They're like judges, but they're not quite as high. They don't do trial cases. They handle the arraignments of the federal prisoners, and they also issue the warrants. So they're kind of helpers. All right. So that the district court level of a trial court level of the federal government. That's if trials, guilt or innocence is decided. Or if it's a non-criminal court, they rule for one party or the other. Above them are the U.S. Courts of Appeals. And there are 13 of these courts that cover the United States. And they hear, obviously, appeals from the district courts. Appeals are usually heard by panels of 3 judges, although more important cases may be heard by a full panel of 6 judges. And remember, appeals are when one of the parties from the lower district court claims that the judge made a mistake or some serious procedural error occurred, and whatever the judge did, a ruling about admitting evidence or a verdict, needs to be overturned or corrected. So that's what happens at the U.S. Court of Appeals level. And right above them, the highest court in the nation, one single court, is the U.S. Supreme Court. It's located in Washington, D.C., and it is made up of 9 justices, one of whom is the Chief Justice, and the others are called Associate Justices. Chief Justice today is Chief Justice Roberts. The justices are nominated by the President, and they have to be confirmed by majority vote of the U.S. Senate. And Supreme Court justices serve for life. We want to make them independent of political pressure and public pressure, so they don't have to worry about being reappointed by politicians or elected by the population. The Supreme Court has the power of judicial review over all federal cases and any state case where constitutional issues arise. The Supreme Court is the ultimate interpreter of the Constitution and the laws of the United States. And the federal court, the Supreme Court, is the only trial court when states have a legal dispute. Otherwise, it is an appeals court. The U.S. Supreme Court almost always handles appeals. However, the one case where they become a trial court is when one state sues another state. This doesn't happen that often, but it occasionally happens. One case that comes to mind was an interesting case, decades ago, over in which state was the Statue of Liberty located in. You had the Statue of Liberty in New York Harbor, and it's right between New Jersey and New York. And based upon maps and title ships and what have you, New Jersey was claiming that the Statue of Liberty was in fact in New Jersey and not in New York. And that dispute was settled by the U.S. Supreme Court. And what state do you think now can claim to house the Statue of Liberty? New York or New Jersey? Surprise answer. New Jersey won that case. Okay, for the U.S. Supreme Court, cases come from lower federal courts and from state Supreme Courts, again, when there are federal constitutional issues involved. Now, in order for a case to be heard by the U.S. Supreme Court, 4 Supreme Court justices must agree to hear the case, and the decision must be arrived at by a vote, and in the Supreme Court, cases are decided by majority vote. So you have 9 justices, 5 or more must vote in a case to determine which way the ruling goes. When the Supreme Court decides to review a case, it issues an order to the lower court to send all the paperwork to the Supreme Court. And this order is called a writ of certiorari. So it's a special court order. It's kind of like a subpoena duces tecum, which is a subpoena to bring documents. Well, in the case of the Supreme Court, when they want to review a case, they want all the stuff the lower court has. So they basically issue a writ of certiorari, and they say, bring us everything so we can review it. Now, of course, the justices themselves don't review all of these documents. They have court clerks who review them. And these court clerks, by the way, are lawyers. They're law school graduates, and they are the top graduates in the nation. It's considered a great honor to be a clerk for a Supreme Court justice. I know clerk sounds like a lowly file cabinet person, but not in this case. Now, and in closing, the U.S. Supreme Court hears less than what percent of the cases sent to it. Remember, this is one court for the entire nation. It takes appeals from all the federal courts and from state Supreme Courts. So of all the cases sent to it, what percentage do you think it hears? And the answer is only 1%. It's extremely selective. So that ends this lesson concerning the structure of the courts at the state, which includes local and federal level. And in the next lesson, we're going to talk about the people who work in the court and the process of how a criminal case goes through. So until then, study these notes, and you can then move on to Lesson 7, Part 2.